Softwares are an essential part of our lives in the 21st century, and they are intellectual creations. So how are softwares protected by the law? And more importantly, who owns a software? These are the questions that we are going to try and answer in today's episode. Think about it. Entire industries and even countries would come to a halt without software. And millions of dollars are spent on research and development in software. But what is the return on investment in developing a software? Hi and welcome back to the channel. In this channel, we talk about the fascinating world of law with a special emphasis on the connection between technology and law. In today's episode, we'll be talking about how softwares are protected by the law. Let's get started. In today's digital society, softwares are everywhere. It runs our phones, powers our businesses, drives our cars, manages our hospitals, and even controls our airplanes. Without it, modern life would literally grind to a halt. But software isn't just a bit of random code. It's an intellectual property. That means it's a product of someone's creativity, innovation, and effort. And just like a book, song, or movie, softwares can also be copied, stolen, and pirated. That's where the law steps in to stop this from happening. To understand how a software is protected by the law, we have to first understand what a software is. A software usually contains two types of elements. Literal elements, that's the actual source code and object code. And non-literal elements, that's the user interface, the design, the overall look and feel, and any audio-visual elements contained in the software. Both these parts can be protected by the law in different ways. Let's first start with the literal elements, which is the code itself. This is basically the building blocks of any software. The source code and the object codes of a software are protected by copyright law as a literary work. That means they are protected the moment that they are written without the need for any kind of registration. This was conclusively decided in the case of Apple computers versus Franklin computers in 1983. In this landmark US case, Franklin copied Apple's operating system directly into its own computers. Apple sued, and the courts ruled that computer programs are literary works under copyright law. The case held that code written in human-readable forms and machine-readable forms are both protected by the law. So in short, if somebody copies your actual code line for line, that's a copyright violation. What about when somebody doesn't copy your code, but copies the layout, the look and feel, or the user interface of your software? The case of Navitaire versus EasyJet in 2005 said that non-literal elements of a software cannot be protected by copyright law. However, the case went on to say that any artistic element of a software can be protected as a copyright as an artistic work. In the case, the courts recognized that an artistic copyright existed in the graphical user interface, designs, and the icons of the software. However, the case did say that functional elements like the single word commands, collection of commands as a whole, and business logic as a whole, among other things, cannot be protected as copyright. Further, in SAS Institute versus World Programming in 2012, SAS claimed that its competitor copied the functionality of its software. The EU courts decided that functionality of a software cannot be protected by copyright. So technically, copying the idea or the functionality of another software is not a copyright violation. But artistic elements like the user interface or the audio-visual elements or the icons of a software can be protected by copyright. Copyright isn't the only way to protect a software. Patents, in some countries, potentially new and non-obvious inventions like inventive algorithms or unique processing methods can be protected by patents. A good example is Amazon's one-click purchase patent obtained in the USA. Trade secrets. You can also protect confidential algorithms or processors that give a competitive edge and retain their value through trade secrets, like Google's search ranking system. And of course, terms of service, user agreements, and NDAs are practical tools to prevent misuse and protect softwares. In real life, most companies use a mix of these methods to protect different aspects of their software. As technology evolves, so will the laws that are protecting it. With AI now writing code and open source communities sharing freely, traditional copyright law is facing new challenges. Who owns AI-generated software? And can open source code be patented? Unfortunately, we still don't have the answers to these questions. Hopefully, the future will involve smarter global frameworks which recognize collaboration and innovation while still rewarding creators for their hard work. So the next time you use an app, remember behind every line of code is a creator, and behind every creator is the law that protects them. Software is the backbone of our digital world, and protecting it ensures that innovation never stops. Check out the video on screen now to learn more about the different types of rights that copyright grants you. And as always, if you like this video, please do consider liking the video and subscribing to the channel. I'll see you in the next one. Take care. Bye.